My name is Xueba. My student number ES3216. Our group will talk about two Australia cases that are related to consumer protection law. Case selection is based on the Australia Consumer Law ACL. ACL is aimed to protect consumers' rights because of weak position and inability understanding completely of product in each transaction. The both cases refer to misleading and or deceptive conduct. In the first case, the company tried to use the exclusion terms to evade their obligation for consumers. In the second case, the company made a misleading presentation on packaging of the Nurofen specific pen product. Now our group member will talk about more details of the both cases.
Hi, Elena. My name is Ying Wang, and my student number is OPS3088. Now I will introduce the background and the legal foundation of Australian Competition and the Consumer Commission and Bannerweight Proprietary Limited. In this case, this is having normal franchise called Bannerweight Pty Ltd, and it expressed some conclusions for the consumer, including the first one, they are not provide the remote for the defective goods which is supplied, and the second one, the consumer would need to purchase the warranty from them, and the last one, they are not helping for the future unless the consumer paid for some and or all of the cost of the repair of the defective goods. The court makes a judgment that they have to pay 52,000 for the fee for making the misleading or making representation recording the consumer rights under the Australian consumer law. And especially according to Section 18, a seller cannot involve in a conduct which is likes to misleading or deceptive the consumer. In this case, Bannerweight make a statement to exclude the consumer power that general a person cannot require the company to replace and refund defective goods according to the first conclusion. And for the second conclusion, when the damage happened, the consumer could only claim the damage from the manufacturer instead of the Bannerweight, and the last consumer noticed unless the consumer pays the money, Bannerweight wouldn't repair the product. However, the Australian consumer law implies many guarantees for Bannerweight, including the seller must have the complete title for the sell the products. Let's welcome the next person to continue the case.
Hi everyone, my name is Mingha Lu. My student number is OPS3082. Now I will show the rest of ACCC v. Bannerweight Pty Ltd. According to Section 260, the major failure happens when a responsible consumer cannot accept this kind of good or service. This is an obvious difference between the significant departure and the description of goods. And the goods will be unfit for their normal purpose for a long time, and it could not be fixed in a reasonable time. According to Section 261, the consumer has the power to replace the goods with reasonable quality and sue for damage. It means the consumer has the power to ask Bannerweight to pay for their goods if there are some defects in the goods which is breach of guarantee of acceptable quality. Those powers are implied by ACL, which means the consumer should have the power to ask Bannerweight to refund or repair or replace the goods, but Bannerweight tries to use the exclusion term to notice the consumer that they don't have those rights, which is the misleading or deception conduct, because those exclusion terms are forced to the facts and the consumer will not be misled by those terms and search the help from other places. This duty is available for all business no matter the business are small or large, and the business cannot mislead consumer about guarantee rights under the Australian consumer law. In summary, the case of ACCC versus Barnum v. Pty Ltd shows a conclusion that a company cannot try to use the exclusion term to exclude the power for a consumer under ACL. Otherwise, it will be a misleading or deceptive conduct, and the exclusion term would be also void, which means the seller cannot really rely on those terms to exclude their powers. When there are the defects in the product, or the product leads to some damages. That's all of my speech. Now let's welcome the next buddy to show his case.